Next case on first appearance docket, State of Kansas versus Brandon Lee Branscombe. Mr. Branscombe, you're charged count one, the only count, with domestic battery. The court sets your next appearance date on Monday, June 30, before Judge Webster.
Yes, Your Honor.
Next item of business is to set appropriate bond. Recommendation for bond, Mr. DeVinny.
Well, Your Honor, in this case, the crime he's charged with here, it was done in front of his kids. He does have a record of criminal convictions, including a battery in 2003, criminal damage to property in 2005, criminal use of weapons, 2009, an aggravated battery, criminal threat and assault, driving while suspended, trafficking contraband in 2011, 2016, driving while suspended, 2022, he had failure to stop at railroad crossing, no child restraints, no seatbelt, interference with LEO, and in 2023, a misdemeanor theft. He does have a record of non-appearance in failures to appear in 2022 and 2025. I don't know at this point if he's still on probation for the 2023 theft, but also has a suspended Kansas driver's license. That's certainly that there be no contact with the victim, no alcohol, drugs, no weapons. And I think he's also involved, there's an open child needed care case involving Mr. Branscombe. In total, Your Honor, given the nature of the charge itself is misdemeanor, but I think a $5,000 cash or surety bond would be appropriate.
Thank you, Mr. DeVinny. Mr. Branscombe, I do believe that a $5,000 cash or surety bond is appropriate.
Yes, Your Honor.
We are on the record in State of Kansas versus Brandon Lee Branscombe. Jared Regier for the state, Darren Patterson for the defendant. All right, this is a motion to revoke or modify bond. The defendant is alleged to have had contact with a Danielle Erskine pursuant to Newton PD number 25-1121. And that would be in violation of the defendant's bond. Mr. Regier, do you wish to proceed on the motion?
The state is prepared to proceed, Your Honor.
Judge, I would tell the court that I have discussed with Ms. Norris a way to resolve the case without taking up the motion. Based upon that, I believe my client is going to enter a plea of no contest.
Mr. Branscombe, I'm told you're going to plead no contest to domestic battery. How do you plead to that?
No contest.
All right, Mr. Regier, you have a factual basis to support this no contest plea?
Yes, Your Honor. Honored at the 16th day of April, 2025 in Butler County, Kansas. The defendant, Brandon Lee Branscombe, did knowingly or recklessly cause bodily harm to another person who is identified as the victim in this case. Additionally, the affidavit in this case does appear to refer to a domestic violence disturbance at a location in Whitewater, Kansas.
Judge, for purposes of no contest plea, we have no objection to the court using the affidavit.
All right, based on the affidavit, I find there is a factual basis to support the no contest plea, and I do find the defendant guilty.
Your Honor, the state's understanding is that upon successfully entering a plea to count one in this case, the state would move in exchange to withdraw the motion.
So are you no longer offering that there was a violation of the no contact order? You're no longer alleging that the defendant violated this court's order by having contact with Danielle Erskine?
Again, Your Honor, the terms of the plea negotiation was that upon successful entering the plea, the state would be moving to withdraw the motion revoking the bond in this case.
Well, you may be withdrawing the motion, but it seems like if we're going to proceed to sentencing, this court needs to know or would like to know if the defendant violated its orders, because that could have an effect on any probation that is made.
Judge, I guess I will speak up. That is part of the plea negotiations between Ms. Norris and I, that that issue would become moot and not part of the recommendations.
Well, plea agreement aside, it's troublesome that a man can be accused of domestic violence battery and the court can order that he have no contact with her. And I'm supposed to just ignore that and proceed with plea agreement. That's troublesome. Well, let's hear what your plea agreement is, gentlemen. Sentencing recommendations from the state?
Yes, Your Honor. The state's understanding of the plea agreement in this case is that the state would be recommending a 6-month underlying sentence as well as a 12 months reporting probation.
Mr. Patterson?
Judge, we're asking the court to adopt the recommendations, including that the no contact order can be lifted upon him getting his domestic violence offender assessment and providing that to his probation officer.
And Your Honor, the state understands after further review of the file that that was also contemplated pursuant to the plea agreement in this case, Your Honor.
This Danielle Erskine, she's his sister, is that right?
Ex-wife, Judge,
Ex-wife.
or maybe common law wife now. They have kids in
Okay.
common.
The kids, okay, they have the kids in common. Okay,
10 years
what?
together. I'm
You have
sorry,
10 years? You and
we
this
have
woman
10
have
years.
10 years? Okay, and 3 kids?
Yes, ma'am.
When was the last time you saw her?
Oh, the day that I was arrested?
In
Yeah.
Newton?
Yes, Your Honor.
All right, now, is this Officer Brett Sargent up here on the screen?
Yes, ma'am.
I suspect you have information about this defendant violating the court's order.
Yes.
All right, tell me just initially, informally, what the involvement is.
And, Judge, I guess I'd have to object because if we're going to get into a full-blown hearing, I mean, that's one thing, but not to have the ability to dispute it.
Fine. All right, fine. Raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Patterson, I don't know what you guys have going on that you're trying to get around the courts knowing that he's been out violating court orders.
And Judge, that's disputed. I'm going to tell the court that's disputed. My client would suggest that he's not the one who had invited this contact, that it was not him, so it's disputed, but that's why we've entered in plea negotiations to avoid the confrontation of a hearing.
Mr. Regier, what do you have to say about not wanting the court to know that there may have been a violation of a domestic battery bond or order that could affect, and why it's important now is it could affect his success on probation? Why should I give probation to a gentleman who may have violated the bond? Why should I think he's not going to violate probation in the same fashion? And because a police officer is involved, it makes me think that maybe the bond involves another battery or something.
Your Honor, all I can tell the court is that the state did anticipate proceeding to a hearing today. However, the state is eager to reach a resolution in this case, and all I am aware of is the terms of the plea deal as negotiated between my colleague and counsel for the defense.
All right, well, I am going to tell you both, I'm not going to sentence him to probation until I know what's really going on here.
Judge, short of getting into a long trial, which is basically what we're talking about, I can tell the court my client was not arrested for a domestic violence event that day. Miss Erskine was, I understand, but my client was not.
Well, why can't Officer Sargent, why do you have an objection to him saying that if that's all it was? I think there's more here than what you guys want me to know.
I'm trying to avoid a long hearing, Judge, and get the
that's
docket done.
fine.
That's exactly what that's a
Well,
purpose.
I'm all about avoiding long hearings that are unnecessary, but I am not going to shortchange somebody's physical well-being and put him on a probation if they've gone out and had another altercation while on bond when they were ordered not to have contact. I'm just not going to do that. So you guys can either have a hearing or I'll just order a sentence without probation. I'm not going to take a chance that somebody is going to get hurt again. And I'm not going to just ignore evidence that's right in my face. So you tell me, Mr. Regier, you're wanting me to do just that? You're wanting me to just ignore that he's apparently gotten into another domestic altercation with her when I ordered no contact? I'm supposed to ignore that? As officers of the court, can you genuinely recommend I do that? All right, folks, I set the bond as my responsibility. I set bonds. As my responsibility, I impose sentences. But before I proceed any further, I have to know what's really going on here. And both counsel have indicated that I shouldn't hear from this officer sergeant. But Officer Sergeant, do you have any information that this defendant violated the bond in this case, wherein I ordered that he have no contact with Danielle Erskine?
I do.
And what information do you have?
On April 24th of this year, we responded to a disturbance between a male and a female. Both the male and the female were located. I spoke with the witness who is here with us today, and she informed me that she watched a man driving a white SUV pull up into the alley near where she was parked. She saw the male exit the vehicle and begin screaming at a woman who was seated in the passenger seat. Upon locating both individuals, they were both identified, and they actually admitted that they had a no contact order.
All right.
I also have another issue at hand. Last week, I reached out to the Butler County Sheriff's Office in hopes to get in contact with them to verify whether or not the bond conditions were still
I'm going
in
to
place.
object as hearsay, Judge, unless we have somebody from Butler County here.
I want to hear it. Go ahead.
I did that because I forwarded this case to the Butler County Sheriff's Office based on the information that the defendant had informed me of, that he had bond conditions. Last week, they were in contact again. We arrested.
Hang on. Who was back in contact again? The man and the woman?
Yes.
Okay.
So what he informed you earlier, that the last contact he had with her was the date he was arrested, and was untruthful.
All right. So the man and the woman in the truck, do you know who they were?
It was Brandon Branscombe and Danielle Erskine.
Okay. Miss Slater, please raise your right hand. Solemnly swear the information and testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. Now, what can you tell me about anything that has to do with this Butler County case?
The only thing I can tell you is what I saw. I believe it was April 24th. I was in Newton for a work-related reason, but was sitting in a parking lot at the Dillons, and in front of me, a white SUV went into the alleyway that was in front of me, and I saw a gentleman exit the driver's side of the vehicle, shut the door, seemed flustered. I could not hear anything that was being said at all. I didn't have my windows rolled down or anything. I was just going off of visual. I could visually see that he was upset. He was yelling at the vehicle. And then after a little bit of time, I don't know exactly how much, he went to the passenger side. And then the passenger side door opened. He did not open it, but it did open. A woman got out, and then they were having a verbal altercation. They walked behind the vehicle, and then I saw her put her hand on his arm, kind of like a, hold on a second, come back kind of thing. And, he pulled his arm away, and he was still yelling at her. I couldn't really tell what her demeanor was, or her reactions or anything. She did have her hands up a little bit, kind of like, whoa, hold on a second kind of thing. And then he continued to walk. He did pass the car. She did get into the driver's vehicle, or the driver's side of the vehicle. They were kind of following each other down the alleyway. I could still see that he was, agitated. He was still yelling at the vehicle. They did stop a couple times. I never saw her exit the vehicle again after she had got out of the passenger side. And then they had come to a street. I don't know Newton super well, but they did come to a street. The back hatch of the vehicle opened and then it closed. I didn't see if anything was taken out or anything like that. And then they did continue to drive down the street. And then when they passed, I believe it's Main Street in Newton, I couldn't really see them after that. I saw her pull into the Little Caesars parking lot, and then I was kind of done with it at that point. I couldn't see anything anymore after that.
All right. Thank you.
Yeah.
Officer Sargent, you're the one then that took the report and worked it.
There were, I believe, 3 of us working that specific case.
Have criminal charges been filed against either party, the Branscombe or Kirkson? Do you know?
Yes, both of them went to jail that day.
Okay, and do you know if the prosecutor filed anything formally yet?
That I'm not sure.
Okay, all right. Okay, well, thank you both very much.
Judge,
Now,
I have a question for the officer.
all right, go ahead, please.
Officer, you said both of them went to jail that day. What were the charges against each of them that they were arrested on?
I believe Brandon was for driving on a suspended license, and the Danielle was for domestic battery.
Okay. Mr. Branscombe was not charged with domestic violence or arrested for domestic violence at that time. Is that correct?
Correct.
That's all I wanted to clear up, Judge.
Okay. Well, folks, I am going to take this all under advisement. I am going to set over the sentencing on this. And at this time, I'm going to revoke his bond. You
And
need
Your
to
Honor,
turn.
Your Honor,
Mr.
as indicated on the record, the state has withdrawn its motion pursuant to
I
plea.
understand, and on my own motion. Mr. Branscombe, where are you at this moment?
I am waiting to enter into a inpatient facility. I've got my assessment and everything. My bed's
I
waiting.
didn't ask you what you are doing. I said, where are you? What town are you in?
I'm in Wichita, ma'am. Your Honor.
Wichita? All right. Are you in a residence? Are you in a treatment facility?
I am at a residence and I'm waiting for the court to be done with so I can go into my inpatient. They told me if you guys needed to speak with them on the court's behalf, you need to speak with them to verify that, for me to give you their number and they would verify that.
What are you going into treatment for?
For drugs and alcohol, Your Honor, I have an addiction problem and I need to get it taken care of.
So you couldn't even report to probation. You're not even ready to start reporting to probation. You're going into treatment.
Yes, yes, Your Honor. I feel that getting myself for.
How about batter's intervention? Have you done an evaluation for that yet?
No, ma'am. I started mental health and med management through Prairie View in Newton. And I've been working with CCRT. I don't know if you're familiar with them, but they're out of Newton, Harvey County. And they have, they also have the BIT program there at their location.
Okay, so you violate bond. You work out this nifty plea agreement with the prosecutor that you don't have to face any consequences for not only violating bond, but going out and getting into a confrontation with the victim. And then instead of reporting to probation, you're telling me, or going to jail, as I could order you, you're telling me, well, I went out and I got myself into an alcohol and drug treatment program. Although the issue in front of this court is domestic violence, it probably is aggravated by drugs and alcohol. Counsel, I feel like you've brought me an impossible situation unless I just order the police to go out, pick him up, put him in jail, and let him serve 6 months. I feel like I have been manipulated to the utmost in this case, and that's not like either one of you two to do that to me.
And Judge, I guess I take offense to the word manipulation. These are standard plea negotiations that I've entered into with the state. So yes, have we entered into a plea negotiation that was to leave out information from the court? Yeah, that's just standard plea negotiations, and that the court has on its own retrieved that information. Well, this is Your Honor, this is your court. I can't really stop the court from doing that since the witnesses are right here. But I think it is a plea negotiation that was warranted and well thought out, and one that we presented to the court.
Well, and I appreciate your offense, Mr. Patterson, but here's why I see it as manipulation. You weren't going to tell me that he was having contact with this victim of abuse. You weren't going to tell me that he was screaming and yelling at her to the point that a citizen called law enforcement and law enforcement came. You weren't going to tell me that he was seen driving while his license was suspended, which is a violation of the law. Bond says don't violate the law. Bond says don't have contact with this woman. Then when I get to sentencing, you've got him signed up to go into an alcohol and drug treatment program that nobody told me about, but it would circumvent reporting to treatment. And what about that statute that says he has a mandatory 48 hours and a mandatory $200 fine, which I can waive if he does the BIP intervention? But he's not set to go into BIP right away. He's set to go into alcohol and drugs. That, to me, looks like manipulation so that he doesn't have to serve his sentence, that he doesn't have to have any consequence for violating bond, manipulation that he doesn't have to have any consequence for what happened in violation of the law while he was on bond. And I'm not supposed to know about any of this. Let's keep the judge from knowing this. Mr. Patterson, that to me looks like manipulation. Maybe it's not. Maybe you don't see it as that. And I respect you as an attorney, and I have for many years, and I respect Mr. Regier as an attorney. And I have for not as many years because he hadn't been at this as long. But this is highly troubling to me that I'm seeing this. And if this is standard and I haven't seen it before and I'm being duped by it, that's alarming, because judges are supposed to know what they're dealing with when they make a sentence. And how's Mr. Branscombe going to deal with this? Again, this is outside of my jurisdiction, but at the same time, what he does in other jurisdictions should affect what he does in this court on probation or as such. But if he's facing driving while suspended charges, but he can't go because he's in treatment?
I don't know that he is, Judge. I haven't seen any charges filed in the city of Newton.
Fair enough. Fair enough. And I know that if they need alcohol and drug treatment, that's a very big, important priority, unless it's designed as manipulation to skirt consequences. Was there even an evaluation, or did I understand him to say he just went and signed up for it?
Judge, I can tell the court the treatment program was not part of this case or part of the negotiations. That is something he's doing on his own. This is the first I've heard of it. The batter's intervention program, on the other hand, is something that was part of the plea negotiations.
Mr. Branscombe.
Yes, Your Honor. I just want to say that I did get a evaluation. Actually, I got several of them over this last about week and a half to try to find the earliest opening bed that I could so I can get into treatment sooner than later. And the one that I found was supposed to be today at 9 o'clock in the morning. I had court at 9, so they extended it till 1. But I have another. They said that it would be okay if I came in tomorrow. If it doesn't work, they told me to give the judge their contact info and that she can contact and talk to you and tell you about how I came about getting there and everything else. I'm not trying to manipulate you, Your Honor.
Mr. Branscombe, this allegedly occurred April 16th. Well, this did occur because we found you guilty. April 16th, 2025. What motivated you between then and today, June 9th, 2025, to go out and get this evaluation?
Well, the loss of my children that were taken from me, me and my wife not being able to have contact with each other.
But you
My
have been
whole,
having contact.
I have, I'm not going to completely lie to you, Your Honor, but it hasn't been like it was. Like we were a family. We lived together. We were with each other every day. We're a family, you know, we have a business together, and it's gone from all of that to, and all of a sudden in one waking moment, my children were taken away. I wasn't allowed to be told where they were. I was told I couldn't have contact with her. So there goes my work because I don't have a valid license. She was the one who drove us, and she was my helping hand in our business. I mean, we have a LLC. We've been open for 3 years, and it's just all of these things were just all at one time. And I just came to the realization that, you know, when we were clean for 7 months just recently, we got off the drugs and we were clean for 7 months. We didn't argue one time, Your Honor, like not one fight. I mean, nothing. And it was awesome. It was amazing. And then we relapsed, and things got worse and worse and worse, you know. And I recognize what it is, and I know that I can't get my family back without me getting myself clean. And it's been on my heart and my mind that I've been thinking about it over the last month and a half, 2 months, and it's time. I want my kids back. I want my family back.
Did you make this appointment after you had contact in Newton with law enforcement?
Yes, Your Honor.
So it wasn't the domestic violence in this case that was the final trigger to make you do the appointment. It was this second contact.
Yes, it's just that it wasn't the domestic.
It wasn't the domestic. Go ahead.
It wasn't the domestic per se. It was just me coming to the realization my family's been torn apart and being held away from me, and it's all due to my usage and, you know, being an addict. And I wanted to get it fixed and then get it right, you know. I don't want to lose my wife and my kids.
Well, you're saying all the right things.
You know, I mean,
Okay. Well, I cannot tell you how many times I have seen someone who gets into your position use treatment as a hiding, as a manipulation, as a way to avoid consequences. Whether
Yes.
you're doing that or not, I don't know. You sound, like I said, you're saying all the right sounds or words. You've got the right inflections. I am going to withhold your sentencing until you complete your treatment, but it better be inpatient, and you contact the attorney as soon as you get close to your out date.
Yes, Your Honor.
And I'm going to get you right back in here as soon as possible for your
Yes, Your Honor.
sentencing. Is everyone clear on that? We'll
And Judge,
continue.
I guess what I'd ask him to do is when he goes to the treatment facility, that he have them send me a report stating he's admitted and what his out date will be. That way we know a little bit sooner than just when he's released.
Yes, do that, because Mr. Patterson, and if you'll get that to me, I'm going to set the hearing in relation to when the out date is set to be, so that I don't just drop the ball waiting for him to contact us, because we know that would not be a wise decision.
Yes, Judge.
But and why isn't the victim here, Mr. Regier? Did she have notice of this hearing?
Your Honor, the state's information is that there has been contact between the victim and my office as recently as within the last 2 to 3 weeks.
Well, make sure she's given notice of this next hearing. It would be helpful to hear from her. July 7, 9 a.m. This matter is continued for sentencing unless, Mr. Patterson, you find out something closer. I don't want him out before I see him again. I don't want him, but you are still on bond. You are not to have any contact with her, Mr. Branscombe. You are not to violate any laws.
Yes, Your Honor, I understand.
All right. Anything further from anyone?
No, Your Honor.
Not from the state, Your Honor.
Thank you. Get to treatment. You better be there at 1 o'clock or it's a violation of your bond.
Yes, ma'am.
All right. And get proof to your attorney.
4 weeks later.
All right, we're going to be on the record in state of Kansas versus Brandon Lee Branscombe, Jared Regier for the state, Darren Patterson for the defendant, who appears in person. Mr. Patterson.
Judge, this is a case where we had previously entered a plea to the charge of domestic violence battery. It was set for sentencing. The court had continued it for sentencing.
Has he finished the inpatient treatment that he was in?
He is still at inpatient treatment, Your Honor.
And he's in treatment for alcohol or drugs, but not domestic violence?
This is for his addiction issue, Judge, yes.
All right. Mr. Regier, are you wanting to proceed with sentencing?
Your Honor, the state is prepared to proceed to sentencing in this matter.
All right, then please proceed, Mr. Regier.
Yes, Your Honor. Pursuant to plea negotiations, at this time, the state is prepared to recommend a 6-month underlying sentence subject to a year of reporting probation.
Mr. Patterson.
Judge, I would tell the court that my client wanted me to know that both of them are currently working with TFI separately, though, because of the no contact order. And he's aware through TFI contact that Miss Erskine is in a meeting. She has a meeting at 11:30 every Monday to meet with the kids, so that she's not available for that reason. I think my client also believes that she should be here to tell the judge what she knows, Your Honor. So that, and I think Mr. Regier stated she wanted to address the court. So we are asking the court to continue the sentencing till possibly when he's out of treatment, August 14.
Mr. Branscombe, you are in violation of your bond condition for no contact because you are not to be having contact with her through
He's getting that
third
information.
parties. He's doing it through third parties.
No, they're just telling him, Judge.
I did not ask, Your Honor. That was just something that they had offered. I even specifically said to Miss Tamara when she gave me that information, if I was going to be in trouble for knowing that I wasn't asking it, and she had just offered that.
Been pulled up.
Yes, sir. Yes, sir.
And I've been told by many places that TFI wants the no contact order lifted so they can have them working together towards getting the kids back. He has not. So apparently they have separate days that they meet with TFI. Mr. Branscombe apparently has contact with them Tuesdays. Miss Erskine has contact with them on Mondays. So I don't know that there's any contact directly or that we considered through third parties.
We'd call that third party if they were anybody but a governmental agency. If their neighbors were doing that, it would be a violation of the bond. If TFI knows there's a no contact and they're doing that, trying to get them back together in spite of the bond conditions and the no contact order, they're interfering with the judicial process. They may have some legal actions of a criminal nature themselves. Because when the court says there's to be no contact, that's what it means, no contact. And TFI is violating court orders by running interference for the parents and trying to get the parents to have contact again. And there are a number of things about this whole situation that just is concerning to the court. The timing and what's going on between the parents and the agency. Mr. Branscombe, when is your release date?
I am not 100% sure, Your Honor. I would have to ask my case manager or them to pull it up on file, but I believe it's the beginning or middle of August. It's a 60-day program, so it is okay.
This matter is
just looked it up.
continued.
It's the 14th.
The 14th of August?
Yes, ma'am.
This matter is continued to September 22nd. Are we looking at a bond revocation hearing on him, Mr. Regier?
Your Honor, this does appear to be a case where the information was signed by my colleague, Ms. Norris.
Well, I show that on May 22nd, 2025, a motion to revoke or modify bond was filed. That was filed by the state of Kansas, alleging that this defendant had been having contact with the alleged victim. And this is the one where the two officers and the civilian came in from the Newton Police Department and testified that they were having that commotion in the alleyway. Do you remember that, counsel? Mr. Patterson, Mr. Regier, remember that hearing? The two of you did not want me to hear from the Newton police officer or the woman that reported them for being in the alley having all the trouble. And recall that I was concerned or suspicious that Mr. Branscombe was hiding, so to speak, in this newfound treatment to avoid his bond revocation.
Judge, I do remember the hearing and that the state withdrew their motion. I do recall that also. And that's why my client entered a plea. But I can't see that his treatment is a bad thing. So I guess I would request the court allow him to finish the treatment he's currently in.
And Your Honor, it is the state's understanding that the state did withdraw the motion pursuant to plea agreement.
That's right. And I recall you both objected to me having the officer still testify as to what he knew about the no contact. It looks to me like my no contact order, or whichever judge.
And Your Honor, forgive my interjection. I believe it. My understanding is that Mr. Patterson was the attorney who had objected to the court eliciting testimony in this matter. My understanding is that the state stayed silent as to that issue, so the state would not have its actions during the last hearing, during the June 6-9 hearing, be characterized in that fashion.
Well, I know that I was discouraged by both parties from hearing the information from the officer and the civilian that saw him during the no contact bond being gruff and abrupt and so alarming that law enforcement became involved, and I believe the charges were filed against him in the other jurisdiction and may still be pending. I don't recall on that part the specifics. Now we come back a few months later and I'm told he's having contact through the Department of Family Services or their agent. This is the most bizarre case I have ever in my life seen, where all the agencies are secreting themselves, so it looks like to this court, I'm secreting themselves to do something for this defendant without the court knowing it. Mr. Regier, I am going to expect an explanation for why the state's governmental agency is running interference for him and his wife, trying to reconcile them, apparently through a child in need of care case, while their kids are apparently in state's custody because of their conduct. And then I want to know why the state isn't as concerned about them having contact, even though the state, no doubt, asked for the no contact in the initial bond set.
And Your Honor, it is the state's understanding that a plea deal was reached between counsel for the defense and my colleague, Ms. Norris, in this matter. I will put a note in the file and communicate with my colleague regarding this matter.
All right, then maybe your colleague needs to be here answering these questions instead of putting you in the hot seat when it's not even your case.
Your Honor, if I may.
No, Mr. Branscombe. I will talk to you later.
Mr. Regier, if you're just the messenger in all of this, then I am sorry that you're the one taking the heat for it. But the attorney that's doing all this needs to be accountable and explain why the state is not concerned about him and this woman having this situation in the alley while he's on bond with no contact, and why she's not concerned about TFI, a governmental agency, again, taking messages back and forth between them. And I'm also afraid to turn him loose from so-called treatment. And I say so-called because I don't know what he's doing, why he's there. I don't know if he's there to really get treatment or if he's just hiding from his obligations in court. But I better have a full-blown account of why he's in treatment at the appropriate time and what the results are. And, you know, this is a domestic violence case.
Judge, we will have a discharge report that will go through his treatment. Also, he is getting a BIP assessment, and Holland Pathways is arranging that for him so he can start on his BIP program also. We'll have that assessment for the court at time of sentencing.
Well, there is something very, very odd, wrong, something going on here that, Mr. Regier, I hope you can convince your colleague to figure it out and explain why these oddities are taking place. Maybe TFI, is it TFI that's doing or it's not DCF, it's their contractor, TFI.
TFI is in charge of the children, Judge.
And they're the ones going back and forth between the parents, telling them what this one wants and what this one wants. And
Judge, I don't know that I would say it like that. I think they're just keeping both parents informed of what's going on in the case.
well, the record will speak for itself, what's been said and not said, so we can always review that and make sure we get it right, what they have been doing. But he seems to know, well, anyway, I'm not going to keep belaboring, we've got too many cases. Boy, I don't think I can, you're going to have electronic monitoring, well, I just don't think I can trust you on bond, but the state seems to think they can. I'm not sure I can trust the state at this point, whoever is responsible for the state, because the TFI is a contractor of the state. The prosecutor represents the state. And something is grossly amiss in this case. But that's your court date. I gave it to you. That's September 22nd.
Yes, Judge.
And you better have absolutely no contact directly or indirectly with her, Mr. Branscombe.
Yes, Your Honor.
I may have to file my own motion to revoke your bond if the state won't do it. And if the state's aiding in it.
I will definitely do what you tell me to do, Your Honor.
All right.
Thank you.
Mr. Regier, I hope you will advise TFI about their obligations to honor a bond and not to aid in violating it. All right, enough said. We're adjourned
Thank
on
you.
this matter.